place where judges uphold the function of the judiciary and the will of the parliament. They are the venue for aggrieved people to seek justice. However, as the society developed and industrialized, more legislation was enacted to govern areas that were previously unregulated. This conferred more rights onto the people in various aspects of their lives. Accompanying the increase of legislation is an increase in disputes, often with regards to whether a person has broken the law. This inevitably led to an influx of claims that overloaded the court system. The judiciary began to encourage people to opt for alternative dispute resolution (ADR) and to view court proceedings as the final resort. ADR is an umbrella term that covers the many pathways to dispute resolution that does not involve the courts. ADR is described as the solution to the problems of cost, complexity, delay that arise out of the antagonistic nature of traditional civil court proceedings. There are many types of ADR, but negotiation, mediation, arbitration, and conciliation are best known. Tribunals are also a form of ADR, but unlike the other ADR procedures, tribunals best reflect the nature of court proceedings. A tribunal comprises of specialist bodies that could help resolve disputes on specialist issues cheaply and quickly. It is known for its cheapness, accessibility, informality, and expert knowledge. ADR has become increasingly central to the English legal system. This is mainly because ADR processes are cheaper and more efficient alternatives to traditional court hearings, which allows people suffering from financial difficulties a channel to obtain justice.
Hi, my name is Wan Tongxiong. I will discuss the issue raised in the scenario and the applications of alternative dispute resolutions with my groupmate, Dae Yiren. The primary issue that Misha faced with her employer Jacob is that she is being laid off in a totally unfair and unlawful manner, as according to the Employment Rights Act 1996, she can claim up to 2 months of paid maternity leave, but in this case, she is being laid off to cut costs from the company in question. According to Section 244 of Trade Union and Labor Relations Act 1992, trade disputes means a dispute between employers and workers. Misha isn't in a good financial spot, as after having a child, she would not have the financial capabilities to hire a lawyer to bring this case to court, as litigation charges and all the miscellaneous fees that accompany it are extremely costly. As such, an alternative for her would be to solve her issue outside of the courtroom in the form of ADR, or otherwise known as alternative dispute resolution. There are a multitude of ways in which ADR can be utilized, but for most cases in which employer and employee relationship hope to be salvaged, the approach with least hostility is taken. According to Gibbons, ADR is the best way to resolve employment disputes or to stop them from happening in the first place. Misha can always try to resolve it by negotiating directly with her company, which is the cheapest and quickest method of settling a dispute. However, experience has shown that there may be cases where the assistance of a third party can help to resolve an issue to the satisfaction of all parties, preferably before relations have become strained or the atmosphere has been soured by the dispute. Therefore, if it is not possible for Misha to resolve the dispute by negotiation, she is advised to use conciliation, arbitration, or employment tribunal as a means of bringing about a satisfactory conclusion. Misha can request for the assistance of advisory, conciliations, and arbitration service, which is also known as ACAS, to bring about a settlement. ACAS is a public body which receives funding from the government and provides free service on conciliation and arbitration to resolve workplace disputes. ACAS have for many years been involved in a scheme which attempts to resolve cases of unfair dismissals voluntarily before the hearing at the tribunal. If Misha does not wish to go to the expense of a formal hearing at employment tribunal, she can opt for conciliation service provided by ACAS. An official of ACAS would be the conciliator, and he or she will try to understand the nature of the dispute and help the parties to reach their own settlement. Conciliators make no recommendations of his own, and the parties are entirely responsible for their own agreement. But usually when parties talk to a conciliator, they would be able to understand the other person's point of view better and eventually come to an agreement. This is especially useful if Misha wants to conserve her relationship with Jacob. With the assistance of a conciliator, Misha can resolve her disputes with Jacob amicably, which enables them to have a good relationship in the future. Besides, since the conciliation service provided by Akas is free of charge, Misha will not have to pay extra fees for dispute resolution. If Misha and Jacob can reach an agreement through conciliation, this may prevent Misha from proceeding to an employment tribunal if she has agreed to refrain from further proceedings. However, if the dispute cannot be settled through conciliation, Misha may opt for arbitration service provided by Akas. Although unfair dismissal is an issue which the employment tribunal has jurisdiction over, and an arbitration after conciliation is rare occurrence, there are still many advantages in proceeding to arbitration rather than to a tribunal. Misha can use Akas individual arbitration to settle disputes. Arbitration is delivered by a neutral person known as an arbitrator. An Akas arbitrator will hear both sides of the case and make an impartial decision. It is flexible in terms of procedure, as Akas will arrange the date and place for hearing which is suitable to the parties. The hearing is informal, confidential, and normally lasts for half a day. After the hearing, the arbitrator will make a decision which is called an award and is legally binding.
Furthermore, ACAS arbitration is not bound by the Arbitration Act 1950, which means there is greater flexibility since the arbitrator is not bound by the law and can therefore apply industrial relations standards in making his decisions, rather than having to adhere to legal standards. Misha is advised to consider conciliation as an option, and arbitration can be a useful adjunct to that. Misha can resolve this dispute speedily, informally, and without the exacerbation of industrial relations through services provided by ACAS. Most importantly, conciliation and arbitration services provided by ACAS are free to the parties. Thus, this will not increase financial burden on Misha after she has given birth. However, the situation would still be disadvantageous for Misha, considering the imbalance of powers between the two parties. This is due to the fact that Misha does not have any legal representation due to her financial state, as such is under far more pressure to agree to reach a settlement, as she can't afford the process of litigation, and thus might agree just to get something out of it instead of nothing at all. Thus, as a last resort, when arbitration 2 fails, Misha can turn into the employment tribunal as a final frontier before litigation is considered. In this case, Misha would be required to submit a claim towards the employment tribunal within 3 months from the date of unfair dismissal. However, Misha would be required to inform ACAS before being able to make a potential claim. ACAS will in turn provide a chance for employees to settle its disputes without it resulting in the tribunal by settling the dispute using ACAS's early conciliation services, which is entirely free. However, if it fails, or if the employee does not wish to go through conciliation, ACAS will issue an early conciliation certificate, which then allows the employee to bring a claim to the employment tribunal via the submission of an ET1 form. After making a claim, an employee's ET1 form is copied and sent to the employer to see if they want to respond or defend themselves. In this case, the employer or respondent is given 28 days to reply to the employee's claim and give their side of the story, which is known as the ET3 form. After this, it is up to the tribunal to decide if a full hearing is needed or if this dispute can be decided via the tribunal without a hearing being conducted. If a full hearing is needed, however, both sides are required to bring their respective documents that should help them win their case, and to organize witnesses in the event if witnesses are necessary. In the scenario of an employment tribunal, Misha is protected under the Equality Act 2010, which rules out a plethora of degree of discrimination as unlawful. In this case, Misha would be placed under pregnancy and maternity discrimination, if only she raises a claim within the time period of the maternity leave or otherwise known as the protected period. If you bring this claim after maternity leave is over, the discrimination wouldn't fall under pregnancy and maternity discrimination, but under sex discrimination. Pregnancy and maternity discrimination is one of the most common claims that women bring to the employment tribunal, with there being lots of instances in the past in which Misha can refer to. As such, Misha's claim has a strong ground for it to succeed, as seen in previous tribunal cases, just as the case of Ms. M. Reeves versus the Hannah Corporation Limited, which is similar to the predicament that Misha is facing now. In the case of Ms. M. Reeves, she was made redundant while on maternity leave, which classifies under pregnancy and maternity discrimination, and thus the tribunal ordered the respondent to pay the losses that Ms. M. Reeves had suffered due to her being laid off. Ultimately, the cost of employment tribunals have been substantially lowered since the Supreme Court decision was passed in 2017, which ruled employment tribunals fees as unlawful. Since then, fees have been lowered, and employees who behave well during the tribunal and thoroughly prepare and have good grounds for their claim typically do not need to pay any costs if they have not lied or misled the tribunal.
Hi, I'm T Hian Yi. I'm here to present the advantage and disadvantage of mediation. First, mediation can save your time. Mediation is most speedy resolution that can save your time to resolve the problem, because it should be remembered that in order to mediate, the claimant usually need an investigation. The court process can be long and difficult, especially if you have a complex case. So mediation provides a more flexible process, as mediator can work on weekday as well as weekend. This can benefit you greatly if you have to arrange decisions around your work or family life. The second element is that mediation is private and confidential. Mediation allows parties to discuss in private meeting area rather than the open forum of the court. It is also important to keep in mind that whatever is said in the mediation meeting is kept between the two parties and the mediator. If negotiation breaks down, the court can't sweep either way by your discussion, giving both sides the chance to state their case anew. Moving on, the third advantage of mediation is flexibility. This is certain true that mediation is more variable because this is greater flexibility than is in the court process. Mediation is not the same as going to court. The evidence you need to present is not limited by normal court rules, and you may be able to include information that will not normally be considered. This can be massive advantage if you have a concern that you struggle to prove your loss under the scrutiny of full litigation. One of the biggest advantages of mediation is that the costs are considered lower, because the hour rate of the mediator may be lower than the rate to hire a solicitor. That being said, if you can resolve the issue early, you could save hundreds, if not thousands of pounds that would have been spent on court costs. Mediation is said to cost less because it's quick, less formal, and without the need of exchange of the full evidence. Nevertheless, the advantage of mediation is that sometimes the mediation will come to a suboptimal outcome, because mediation does not always result in the settlement agreement. Sometimes the party might spend their time and money in mediation only to find that they must have their case settled for them by a court. The second disadvantage of mediation is there are no guarantees. The main disadvantage to mediation is knowing there may be a chance that negotiation could fail too if the other side is adamant they are right, refuse to listen to what you want to say, or won't agree to mutually benefit terms. Then the case could end up going to court anyway. The mediation process and the outcome could be adversely influenced by mediator's own attitude and assumption regarding what would be an approach settlement, and indeed what is a fitting way for a disputer to behave. Moving on, mediation requires cooperation. When coming into face-to-face situation, an official in the round table discussion, there will be stress for some claimants. If one side refuses to do so, then mediation may not work for you. If one side has any reason to feel intimidated by other party, a successful resolution will not be reached.
Flexibility is clearly the main advantage of arbitration.
The parties may decide not to hold a hearing and resolve the dispute only through documentary evidence. The parties have several options, from a simple loose-leaf arbitration in commodity trades to the formality of a hearing with attendant counsel and concomitant exchange of formal pleadings. From flexibility comes speed and saving of costs, although it can be said that certain arbitration can and do extend for a long period of time. This is not necessarily the case, and they can be very much faster than litigation. The courts cannot turn away the plaintiff because the list is overcrowded. On the other hand, an arbitrator will usually never accept an appointment unless he feels confident that he can deal with the matters expeditiously. The aim is a low-cost resolution of disputes. Arbitration is usually less expensive than court litigations, mainly due to the compressed schedule for completion of discovery and trial. It is often possible for the parties to draft their own submissions rather than to instruct solicitors to do this. When solicitors have used, they can in very many cases do all the work without the need to instruct counsel. This discipline of setting down issues on paper marvelously exercises the mind and encourages restraint. Concise and cogent arguments can be presented. There are particular advantages to be gained by the parties. They are able to set out their own cases at length. They can mull over their submissions, revising and rephrasing them, something they would be unable to do when giving oral evidence. They might even draft their own submissions without the necessity of instructing a solicitor to do this. After gathering up and submitting their evidence alone or through their solicitor, they need only await the publication of the award. They lose no time from work. They have been spared the once and for all opportunity to present their case. They are spared the expense of hearings, which even though they may have instructed solicitors to advise, negotiate, make submissions, and so forth, they are also spared a possible sense of grievance which they might feel that their valid claim was demolished by adroit cross-examination and not so much at the attainment of justice of the case, but at the presentation of the case to the best advantage. They suffer no anxiety or stress about the court appearance. Another advantage is the convenience of both parties. An arbitration can be held in a place chosen by both parties, which is on neutral territory, in say, the hotel in which the defective carpets were laid, or on a remote island where the installations which are the subject of the dispute are situated, at times to suit the parties. The hearing could be in the evenings or in the weekend, in order that parties and witnesses need to lose no days of work. The arbitrator is appointed by the parties, and thus, the convenience is that of the parties, not of the court. The major disadvantage of having a dispute resolved by arbitration on documents alone is that there is no hearing. And in order to evaluate these advantages, all that needs to be done is to list the advantage of an oral hearing. It cannot be denied that an adversarial or contradictory procedure guarantees a high quality of adjudication. It is the best means of resolving conflicts or factual evidence to see and hear witnesses who give their own account of the facts in dispute and who are then cross-examined to test those accounts. Witnesses are an oath, but it is probably true to say that they would be far less likely to make false statements in open court, whereas they might be tempted to do so the more readily in a document. Furthermore, the ability to continue to lie with any conviction while it is under competent cross-examination is rare. It is difficult and sometimes impossible to clarify points on the document.
The advantage of conciliation is its informality and flexibility, where the decision that both parties have agreed on need not to be a strictly legal one sticking to the letter of law. The disadvantage is that the finality of the outcome is not legally binding on the parties, and hence it may not lead to a settlement, and parties may seek to proceed to court proceedings if the conciliation process had not been successful. Another alternate dispute resolution is the tribunals, and the advantages are the tribunals were set up to prevent the overloading of the court system with extra cases claiming for social and welfare rights, and it's cheaper as compared to court hearings, since tribunal hearings don't cost as much as court hearings, as the parties in the cases are encouraged to be represented by themselves, unlike court cases where courts may issue an order for cause. The tribunals rarely make such an order, hence parties do not have to fear a large bill if they lose the case. Most tribunal hearings are very short, with some cases being able to be dealt with in just one day, while court cases are usually very lengthy and time-consuming. In formality and flexibility, the decision that both parties have agreed upon need not to be a strict legal one sticking to the letter of law. The disadvantage is that the finality of the outcome is not legally binding on the parties, and hence it may not lead to a settlement, and parties may seek to proceed to court proceedings if the conciliation process had not been successful. Another alternate dispute resolution is the tribunals, and the advantages are the tribunals were set up to prevent the overloading of the court system with extra cases claiming for social and welfare rights, and it's cheaper as compared to court hearings, since tribunal hearings don't cost as much as court hearings, as the parties in the cases are encouraged to be represented by themselves, unlike court cases where courts may issue an order for cause. The tribunals rarely make such an order, hence parties do not have to fear a large bill if they lose the case. Most tribunal hearings are very short, with some cases being able to be dealt with in just one day, while court cases are usually very lengthy and time-consuming. The informality of tribunal hearings is also one advantage, as tribunal hearings are less formal than those in courts, and the use of lawyers in tribunal hearings are discouraged. Besides, most cases are heard in private, so the parties can enjoy confidentiality and privacy, as court hearings are open to the public, with journalists and reporters attending court hearings. Especially for novel cases, court cases as such may be published. In tribunal hearings, it is set in a panel of 3 consisting of 2 lay members and a tribunal judge. These lay members are experts in the type of case being heard. Hence, they are said to have a comprehensive understanding of the issue in dispute. However, the disadvantage of tribunals is that the tribunal system lacks public funding, and this is disadvantageous to the applicant if the other party hires a lawyer to represent them. Legal aid is only made available to cases involving infringement of human rights for tribunal hearings. It is also more formal than other methods of ADR, and this may increase the confusion of the individuals in the procedure of presenting themselves. The number of cases dealt with by tribunals may imply that there can be delays in getting a hearing. One contributing reason to the delay of tribunal hearings is the use of lay members, as they only sit part-time, usually 1 day a fortnight. Hence, if they are hearing a complex case that lasts several days, proceedings may be spread over a number of weeks or months. It can be concluded based on the points above that the many advantages of ADR outweigh the disadvantages of having used any ADR in resolving disputes. The main advantages are the length of time in ADR is shorter, the process in resolving disputes is faster than having brought the issue to the court. It is also more cost efficient, more flexible, and less stressful than having to deal with a court case. ADR provides grounds for the parties to agree on resolutions that are not available in court, as the only remedies awarded by courts in a civil case are either monetary damages or one of the equitable remedies. But with ADR, parties may ask for a variety of resolutions. For example, repayments of the debt may be restructured over a long period of time. ADR also allows business parties to make agreements on their future conducts, which is something courts could never have provided. Though tribunals are a more formal process than the ADR, it nevertheless still carried a number of advantages that may benefit the parties in dispute. However, according to the discussions above, it could be encouraged that MISHA should seek an ADR since it is a cheaper method and it aims for an amicable resolution.
Misha was fired when she was 20 weeks pregnant, and the rationale of her employer, Jacob, was that the company could not afford to hire a part-time employee to take her place when she is on maternity leave. Since Misha is not financially capable of bringing a claim against Jacob through litigation, she is encouraged to opt for ADR since they are generally cheaper than civil litigation. Misha is advised to first negotiate with Jacob, as negotiation is characterized as a preeminent mode of dispute resolution. It is the most flexible and the least hostile form of dispute resolution if done in good faith. Negotiation is also highly recommended, for it can best preserve or even enhance the relationship between parties upon an agreement. Should negotiation fail, Misha could approach ACAS to proceed with other methods such as conciliation and arbitration. Both methods involve a neutral third party, though the role of the neutral person differs for each method. The involvement of a neutral third party is advantageous to Misha since it can flatten out the potential power imbalance between her and her employer. In arbitration, the arbitrator, who may be a lawyer or an expert in the field of the dispute, will make a decision for the parties. The decision is legally binding and enforceable through the courts. Main advantages of arbitration that benefits Misha are its low cost and flexibility. Should an agreement be concluded under arbitration, Misha would essentially obtain an outcome similar to what she would get through litigation at a reduced cost. She will also be able to insist on the arbitration being conducted on neutral grounds to further prevent the occurrence of power play. Conciliation, on the other hand, is a process with the aim of helping the parties come to a mutual agreement. The conciliator will not make a judgment for Misha and Jacob. They take on a guiding role in helping them identify the issues to the dispute. However, the conciliator also takes on an interventionist role, as they would suggest possible options to resolution. Conciliation is beneficial to Misha since it allows for the preservation of her relationship with Jacob, as conciliation often helps the parties come to an understanding. Moreover, the conciliation service under ACAS is free of charge, which is suitable for Misha knowing her financial status. However, it is worth noting that conciliation is a term that is slowly fading into disuse and is often referred to as mediation, since there are very little differences between the two procedures. If all fails, as a last resort, Misha could always approach the employment tribunal. Although tribunals exist outside the ordinary court of law, they still adhere to principles of natural justice, which ensures fair hearing for both sides and impartial decision-making. It is also within the tribunal's jurisdiction to issue compensation or specialized action. This means that if Misha's claim is successful, she could choose to either receive damages or get her job back.